Good afternoon, everyone. Welcome to the GradChat program. And today we have Jen Lynch from Victoria Legal Aid, who will be providing an overview of the discrimination law. So before I start, it's once again a wonderful afternoon today on Wednesday, where many of you may have completed your exams. And yesterday we had an interesting town hall meeting, a virtual one with our graduate researchers, who had many issues emerging for them as graduate researchers while they kind of navigate their world in the COVID-19 period. And I would say still COVID-19 because we are having an we will be soon having some lockdowns in certain areas. So I guess before I commence, I'd like to, on behalf of GSA, acknowledge the traditional custodians on the land from where I am virtually broadcasting. I acknowledge the Wurundjeri, from the land of the Wurundjeri people of the Kulin Nation. And I'm aware that, you know, there are people listening to it from different parts of Victoria. So I'd like to pay my respect to the past, present and emerging leaders of the land, and pay my respect to the Aboriginal people and the Torres Strait Islanders. So I think for us, it is, we're so fortunate to have Jen today because I think some of the concerns, even just from a brief meeting that we had from some of our graduate students, was the concerns about raising issues and feeling that you may be discriminated by either your supervisor or the university because you've had to disclose some information, or generally your experience in being employed in a particular place, or having to, you know, wearing a particular dress, or having to practice a particular religion, that you have, you know, felt discriminated. And some people have felt that is life for us in a different country. Some people have felt that is life for us because, you know, we don't share the common views or the acceptable views as the society puts it. But today, I think as an organization from the University of Melbourne, the Graduate Student Association definitely want to bust those myths. And we will continue progressing this strategy by having guest speakers. And today I'm very pleased to have Jen Lynch, who's our lawyer in the Equality Law program at Victoria Legal Aid. So the Equality Law program specializes in providing legal advice and assistance in relations to discrimination and sexual harassment claims under the state and federal discrimination laws. And Jen has worked at Victoria Legal Aid for 3 years, including 2 years working in the Mental Health and Disability Law team, providing legal advice and advocacy in the relation to the Mental Health Act. So GSA would just like to kind of remind all our listeners that when we invite guest speakers, that we understand it's a part of a community legal education strategy where we're privileged to have Jen to give us some legal information. And if you need specialist legal advice, she will also provide you referrals on where you can seek it. So welcome on board, Jen, and thank you so much for joining us. So over to you.
Thank you very much, Rachna. I'm very excited to get to speak with you today on this topic. So I'll just share my screen with everyone so you can see my slides. Just a moment while I do that.
I'd also like to welcome all our listeners who have joined us today. So it's fantastic that you all have been able to come along today.
All right, I'll just check that Rachna, can you see
I can
the
see it very
slideshow?
well. Very
Great.
well. Thank you.
That's wonderful. So thank you again for inviting me to present this afternoon. I would also like to start by acknowledging the traditional owners of the land on which I'm working from today. That's the Wurundjeri people of the Kulin Nation, and to pay my respects to their elders past, present and emerging. as Rachna explained, my name's Jen Lynch and I'm a lawyer working in the Equality Law program at Victoria Legal Aid. We're a team of lawyers who specialise in discrimination law and sexual harassment law, and we are Victoria's largest provider of free discrimination law advice and assistance. And so I will have some information about referral details for our service at the end of the presentation for anyone who would like to contact us. So the aim of this session is an overview of discrimination and sexual harassment protections. The aim is to help you identify situations that could be discrimination, sexual harassment, or racial or religious vilification. What we know from research is that discrimination occurs a lot, but that the numbers of people actually making complaints of discrimination is relatively low. And there are a few possible reasons for this, but one of them is that people don't necessarily understand their rights or know what they can do about discrimination. So I'll also provide you with some information about the process for making a discrimination claim and some potential outcomes of bringing a claim as well. As I said, I also have a slide later in the presentation with some information about the services that our team offers and some information about how to get in contact with us. So this slide is an overview of the elements, or the three main elements of the discrimination protection. So the first one being that the conduct needs to have occurred in an area of life that's protected under discrimination law. So not every interaction is protected under discrimination law. The conduct will need to have occurred in an area of life that's actually protected under our laws. So for example, that could be in the workplace, it could be at a school or university, or in the provision of goods and services. And there are other areas that are covered as well. The second aspect is that the person must have been treated badly or unfavourably by someone else. And the third is that that bad or unfavourable treatment needs to have been because of a protected attribute that that person has. So I'll discuss each of those elements in more detail over the next few slides, but that's an overview of the aspects of a discrimination claim. So the first one being the attributes that are covered by discrimination law. So the protected attributes are actually outlined in each piece of discrimination legislation, and a discrimination claim can only be made on the basis of those protected attributes that are outlined in the legislation. So some examples of this depicted on the slide are things like a person's race, their religion, a disability that they might have, their sex, sexual orientation, and their age. And there are others, and there are some that are specifically in our Victorian discrimination law, but perhaps not in our federal discrimination law. So there is some variation between the different pieces of legislation. It's worth noting that currently criminal record discrimination is actually not a protected attribute. There is some limited ability for people to make a complaint about criminal record discrimination to the Australian Human Rights Commission. So when people call our team at Legal Aid about this, we can give information about those options. But criminal record is not actually at the moment a standalone protected attribute that's protected under our discrimination laws.
So Jen, I may just for the viewers' clarification, when you use the word criminal record, it's like when employees are asked to do a police check, right, and if there are findings against them, is that right?
Exactly, that's right. So as is standard now, almost all employers will do a police check of a potential or current employee, and at the moment, and we see a lot of inquiries about situations where people either aren't successful in obtaining a job or have their employment terminated because certain past criminal history has shown up in that check. And at the moment, that's not actually a protected attribute that somebody can bring a discrimination complaint about. There is some limited, as I said, ability to bring a complaint to the Australian Human Rights Commission, and the Australian Human Rights Commission can investigate and hold a conciliation about that, but it's quite limited. So it's an area where we see a lot of inquiries, but it doesn't have the same level of protection at this stage that other attributes do.
Thank you.
not a problem. Some things that are unfavourable or bad treatment but won't fall within discrimination laws are things like bullying, so being treated badly where that unfavourable treatment is not linked to a particular protected attribute that the person has, or being treated badly because of for example, a miscommunication or a misunderstanding. So if your boss thinks that you've done something wrong when you actually haven't, and you're being treated badly because of that, that's not going to fall within discrimination protections. There needs to be that causal link to a protected attribute for it to be protected. As I said earlier, only conduct that occurs within certain areas of life or within particular protected relationships will be protected by discrimination law. So, for example, we see a lot of inquiries in the employment context. That's very common. And then also within schools, universities as well, and things like sports clubs, and also in the provision of accommodation and goods and services. They're all areas that are protected under discrimination laws. So a good way to think about it is if the bad or unfavourable treatment involved in interaction with an organisation, then it's likely to be covered by discrimination law protections. Whereas bad treatment, which is an interaction on the street, for example, with a stranger, or with a neighbour, is unlikely to be covered under discrimination protections. However, we will talk later in the presentation about racial and religious vilification, and this is a separate protection to discrimination, and it's a protection that can apply to interactions that do happen publicly on the street or with a stranger, provided other criteria are met. So they're not limited to the same areas of life or relationships that discrimination protections are. In the next few slides, I'll cover the different types of discrimination that are protected under our discrimination laws. So the one that you're seeing here is direct discrimination, which is the most obvious form of discrimination. It's what people think about when they sort of first think of discrimination. It involves being treated unfavourably or badly because of a protected attribute that a person has. So you can see from this slide a common example of direct discrimination, and something that we get a lot of inquiries about is pregnancy discrimination. So in this case, an employee is being treated unfavourably by having their employment terminated because of their pregnancy status. However, direct discrimination can occur also in a university context. So for example, if a university made a decision not to admit a student to a particular course on the basis of their sex or race or another protected attribute that they have, that would also be covered under direct discrimination.
Jen, I have a question at this moment, just
yes,
a relevant one.
Yes.
Is that, let us say we have, as people are enrolled in different courses, or we find ourselves in this difficult period in COVID-19, that sometimes, some students do feel that, unreasonable, they're experiencing different kinds of difficulties, and they've been asked to provide information, personal information to their supervisors, and felt that the information that they have provided has adversely impacted on them. Would that be would that fall within a discrimination law, or what is your view? Is that something that people can seek some legal advice on?
Yeah, it's certainly something that you could seek legal advice from our team about. There are protections in, for example, our Victorian Discrimination Act, which is the Equal Opportunity Act, for protecting against discriminatory requests for information. So, for example, a person cannot request or require another person to supply information that could be used by the first person to form the basis of discrimination. So some requests for particular information could, or it would be worth seeking legal advice about whether it falls within this protection. There are exceptions to that. So if an organisation or a body is able to show that that information that they're requesting is reasonably required for a purpose that doesn't involve prohibited discrimination, then there are exceptions that that organisation can rely on to say that that's not discriminatory conduct. But it's something that certainly you could seek advice about from our team.
So is it kind of, we have a question here, like, you know, when a university asks a student to kind of say, you know, you have to provide a disability access plan to your supervisor at the beginning of every semester, which is maybe an organizational policy with all very good intentions, which is, you know, to support the person through their educational journey. Yes. But if that kind of led to the student feeling that they have been, you know, at some point it has any adversarial impact on them, is that a place that, you know, it's good to kind of get some peace of mind, getting some good legal advice on, isn't it?
Yes, it would definitely be worth getting legal advice about that. I mean, I guess there's two parts to that question. One is the actual asking for the information or requesting the information in the first place. And then the second part is if any unfavourable treatment then by someone within the university is because of a person's disability or because of information they then have, then that could form the basis for direct discrimination. So I suppose there's two parts to that. But I do think it's something that would be worth speaking to our team and getting some legal advice about on the individual, you know, on an individual case-by-case basis.
Thank you.
No, not at all. Was there any follow-up to that question, or are you happy for me to sort of continue?
No, if you can, I think it's a good one, and I think it covers what the member of the panel also have been writing. Yeah,
great, thank you. So as part of direct discrimination is this idea of being discriminated against on the basis of characteristics of a protected attribute. So sometimes unfavourable treatment won't be because of an attribute directly, so won't be because of someone's sex or race directly, but will actually be because of a characteristic of that protected attribute. So if something is found to be a characteristic of a protected attribute, it will also be protected by discrimination law. So for example, there's an explicit protection in our Victorian Equal Opportunity Act, which provides that the use of an assistance aid, such as an assistance dog, by a person with a disability will be treated as a characteristic of that person's disability, which would mean that then if someone is discriminated against or someone is treated badly because of their assistance animal or their assistance dog, that itself will become an issue of discrimination. So in relation to other attributes, for example, the attribute of race, some characteristics of a person's race might include their skin colour, their name, their language, and so therefore unfavourable treatment on the basis of those characteristics will give rise to a race discrimination claim. An example on this slide is a person of Muslim faith who's declining to shake an interviewer's hand. In this case, the act of avoiding certain forms of physical contact would be viewed as a characteristic of this person's religion. And so therefore, if they, for example, didn't get a job or were otherwise treated unfavourably because they declined to shake the interviewer's hand, they could bring a claim. They could bring a claim on the basis of religious discrimination, arguing that this is a characteristic of their religion and therefore is also protected under discrimination law.
Thank you.
This slide covers the idea of indirect discrimination. So the idea behind indirect discrimination is that equal treatment doesn't always lead to equal outcomes and can actually amount to discrimination. So the image on the slide is a good representation of this idea that in some cases treating everyone the same can actually be discriminatory. So in terms of the legal definition, indirect discrimination is when an organisation or a company impose a requirement, condition or practice which appears to treat everyone the same, but actually has the effect of disadvantaging a group of people with that particular protected attribute. So some examples of this might be an employer who imposes a requirement on that all of their employees must work between the hours of 9 and 5. And this is a requirement that's the same for all of their employees. However, it's actually going to disadvantage parents who have responsibilities to pick up their children before and after school and actually can't, because of their parental responsibilities, they're not actually able to work those same hours that the employer is expecting everyone to work. In a university context, if a university was to have stairs-only access to some of their lecture theatres and tutorial rooms, and this meant that a student in a wheelchair could not access the building or could not access particular lecture theatres or tutorial rooms that they needed to access, then this would be an example of a practice that's disadvantaging a group of people with a particular protected attribute, even if it appears on its face to be neutral or non-discriminatory.
Jen, there's another question. It's more a question or a comment. It's based, it's mainly based on, I have a perception that because I don't speak very good, I'm not from Australia and I don't speak very good English, that I feel that often I'm treated differently, or I feel I'm being discriminated. Do I have a legal recourse?
That's an interesting question, and certainly one that you could speak with our team about. I guess one of the challenges is that language skills or language ability are not necessarily in and of themselves, that's not necessarily a protected attribute in and of itself. So in order to fit it into a discrimination claim, you'd need to be able to link it to a protected attribute that is protected. That could be challenging. You could try and link it to being part of your race, but there'd be a question around whether you could say that that's a characteristic that everyone of that race, that's pertaining to that race generally. So it wouldn't actually be a straightforward discrimination case to argue, but it's certainly something that you could seek legal advice about.
Thank you.
That there'd be that challenge of linking it to an existing protected attribute that is protected under our discrimination laws.
Absolutely. And another one is that would this apply to requirements which in case of an employment that is which are informally enforced on employees? Like, for example, if you're unfairly treated by your manager because you don't attend the end of year drinks because you're not the person who drinks alcohol and believes that that these are the events where sexual harassment happens, and principally you don't want to attend them. Can you be, and you're saying, you feel your manager's treating you unfairly because you're not one of those team players who go to the end of year drinks? Is there
potential recourse? That's a really interesting one as well. So just to make sure that I've got the question right, you're saying where you're being treated differently because you're declining to attend particular functions where alcohol is likely to be served because your preference is not to attend that type of function. Would you be able to bring a discrimination claim? And
I mean, I guess, you feel you've been treated differently by your manager or not treated fairly.
Yeah, that again is quite difficult because whether or not your decision to attend or not attend functions, again, so in that example, the reason you're being treated poorly by your manager is because you've made a choice to attend or not attend particular functions. That in and of itself is not a protected attribute that's protected under discrimination laws. However, for example, to bring indirect discrimination into it, if you could show that your employer has a requirement, condition or practice that all staff must attend these events where a lot of alcohol is served. And if, for example, I'm not saying this is the case in your case, but if, for example, a particular employee, because of their religion, was someone who didn't drink alcohol and they were uncomfortable because of that attending those workplace events, you could try and argue it as indirect discrimination in that way. But in terms of a direct discrimination claim, it would be difficult, again, because the challenge would be linking it back to a protected attribute that you have.
Thank you, Jen. Yeah, thank you.
That's
and just
okay.
for listeners, it's often difficult for lawyers to give advice on a particular situation because, you know, they do need to kind of get an overall view of the entire situation. But I think it's a good, one good suggestion that I always ask people to do is definitely seek the advice of qualified lawyers and services, because the Google may lead you to places which may not be the appropriate application of your situation. So thank you, Jen. We'll continue.
No, thank you. So I think we were just finishing off with indirect discrimination.
Yes.
So just to say that these are some examples. So for example, someone not being able to access lecture theatres or tutorial rooms if they are using a wheelchair, that would be an example of indirect discrimination where that university is not making accommodations for that person. And that brings me into there's an obligation imposed on employers, universities and service providers to make reasonable adjustments for someone with a disability. So the employer, university or service provider will only be required to make adjustments which are reasonable, and a court or tribunal will consider what is reasonable on a case-by-case basis. So they'll be looking, there's actually a list of sort of considerations in discrimination legislation, but they'll be looking at things like what is the nature of the adjustment that the person with a disability requires to perform their role, and what are the circumstances of that business or organisation who will need to make the adjustment. So looking at the size of the business, their resources to make the adjustment, and what the impact on that business or their staff would be of making that adjustment. But some examples of adjustments that we get inquiries about over the phone in someone's employment could be an adjustment to work from home 1 day per week, or to not perform particular duties in their work, such as lifting heavy objects because of a back injury that they have. Or in a university context, it could be moving a particular course or event from an inaccessible venue to an accessible one, or ensuring that there are subtitles in an audiovisual presentation for a lecture or a tutorial. If we do see a lot of these requests, and if a person is planning to ask their employer or their university for an adjustment on the basis of a disability that they have, it's good to ask in writing and to provide some medical evidence to their employer or to their uni to support that request. So particularly some medical evidence to make the link between the disability that the individual has and why that particular adjustment is required on the basis of their specific disability. When our team assists with these types of claims, often the first step for us is to write to the employer or the university making a request that the adjustments be made, rather than sort of filing a complaint straight away. And on that, I should note that the requirement to make reasonable adjustments is also the obligation on employers to make these adjustments for people with parental or caring responsibilities. So caring responsibilities could be for elderly parents or grandparents, or for, you know, a loved one who is unwell. So sexual harassment is also covered under our discrimination laws. And people are protected from sexual harassment that occurs in their employment, at their university, and in other protected areas of life. As you can see from the slide, sexual harassment is an unwelcome sexual advance or unwelcome conduct of a sexual nature in circumstances where a reasonable person, having regard to all the circumstances, would anticipate that the other person would be offended, humiliated, or intimidated. So in terms of what could be other conduct of a sexual nature, it's quite broad, and it can include things like someone talking about their sexual exploits on the weekend or making rude jokes that have a sexual element to them, for example, in a workplace or in a university environment. The focus is on whether a reasonable person, knowing everything that the harasser knew, would have anticipated that the other person would be offended, humiliated, or intimidated by that conduct. And something that's really important is when assessing whether something amounts to sexual harassment, it doesn't matter what the motivation or the intention of the harasser is. So it doesn't matter if that person thought they were making a harmless joke. If a reasonable person would anticipate that that conduct would offend, intimidate, or humiliate the other person, then it will still be sexual harassment regardless of the harasser's intentions or motivations. And we do see cases where people experience within the same context, so within their workplace or their university, both sexual harassment and a form of discrimination. And under Victorian law, Victorian discrimination law, they can bring both of those claims within the same case. So they can bring a case that has discrimination on the basis of particular protected attributes and sexual harassment in the same proceeding.
I had a question for you, Jen, is when students are studying in a university or, let us say they are in a placement situation and they're experiencing, sexual harassment at either the university or in their faculty or at the workplace, is that, there is a process that has been prescribed by the university, some very proactive kind of support offered by asking them to contact particular areas. Is it, suppose a person who's experiencing this harassment, do they have the rights to go outside the university setting to pursue this process when they have been in this uncomfortable situation, or is it mandatory that they only follow the process that has been provided by the university?
Yeah, that's a really good question, a really important question. No, it's absolutely not mandatory to follow the process that's provided by the university. Some people would choose to make an internal complaint first, and that's certainly open to them to do that. But people do not need to make an internal complaint first. They can choose to seek legal advice and make an external complaint to one of the human rights commissions or to VCAT in Victoria without there's no mandatory process internally that they have to go through before they do that. It's more that some people prefer that internal process as a starting point, but certainly there's no obligation to start there. And we get a lot of inquiries about sexual harassment in the workplace and in other contexts as well. And so if you have experienced any conduct which and the definition, it can be a little bit hard sometimes to work out whether, for the individual to work out whether the conduct fits within the definition. So I would certainly recommend you calling us and seeking some legal advice about whether it fits into that definition and what your options are. Something we can definitely help with.
Thank you very much. So is there also a limit of time for reporting sexual harassment?
Yeah, another good question. Not for reporting it per se, but to file. There are some time limits for filing complaints, for filing civil sexual harassment complaints. So we've got protections under the Equal Opportunity Act in Victoria, but also under the Sex Discrimination Act at the federal level. And they actually have different time limits, which I will go through later as well. So the Victorian Equal Opportunity Act, complaints should be made ideally within 12 months from when the sexual harassment occurred. And under the Federal Act, ideally within 6 months from when the harassment occurred. However, That's not to say that those time limits mean that people can't ever make complaints outside of the time limit. They can. It's just a harder process and there are more obstacles. But so it's better to get your claim in within those time frames. But we do see cases where people are making claims out of time as well, and it is possible to do that, just more difficult.
Thank you.
Yeah, not a problem. So, were there any other questions that related to sexual harassment, Rachna, just before I move on?
I may just tell the participants, if there are any questions, guys, just put it on the chat program and I can see them, and so can Jen and Andrew. But it is important if you have any questions. I think, Jen would be able to give you some general information and advice, but there's always going to be an opportunity for you all to use legal aid services after the program to seek some advice. So at the moment, no questions. So please move on, Jen.
Great, thank you. Another important protection in our discrimination laws is victimisation. So the idea of victimisation protection is that people should be able to make complaints of sexual harassment and discrimination without being subjected to a detriment or treated badly because they made these complaints. So it's really important that people feel safe to make these complaints without being concerned that action will be taken against them by their employer or university because they did so. So this protection of victimisation covers people who've made an informal complaint. So for example, within their workplace to their HR department or just to a manager about discrimination or sexual harassment. But it also covers people who've made a complaint to one of the Human Rights Commissions or to VCAT. And when people make these complaints, for example, if someone was to make a complaint to their HR department or to a manager in their workplace, they don't have to use the words discrimination or sexual harassment to then be protected by this victimisation protection. Just describing a complaint which describes conduct which would be sexual harassment or discrimination will be sufficient to then be protected from any detriment that you're subjected to for making that complaint. So some examples of victimisation could be someone having their shifts cut or their hourly pay rate decreased because they complained to their manager that another senior employee had been discriminating against them. So it's that kind of action that's taken because you've made that complaint. There has to be that causal link between the being subjected to that detriment and making the complaint.
Jen, there's a question which I think is a very important one, is that I think we do sometimes, I think because of the nature and the historical nature of the sexual harassment, talk about a lot of women, but there's a question where if it's a female colleague saying something offensive, but she said it was joke, and as a man, you shouldn't complain. What should be done to stop this? And cause, is this like, if this person completely denied it and there's no way to prove it? One is the frustration is, as a man, do I have the right to have a question? Have an ability to complain? And second thing is that I guess historical context has been women are more subjected to this kind of behavior from men, and feeling that sense of frustration because you can't prove it. And any comments on that, please?
Yeah, absolutely. Starting with the first point, so there's certainly no restriction in terms of, although yes, largely we do see inquiries from women being sexually harassed, there is no restriction between which gender or what gender identity could experience sexual harassment. So anyone who has experienced conduct that fits into that definition of sexual harassment can make a complaint about sexual harassment. There's really no restriction there. Although yes, largely we do see complaints from women predominantly. And the second part to that, yes, it is difficult in terms of a lot of people are not going to necessarily have any written or documentary proof of sexual harassment, and often there are no witnesses to sexual harassment because people don't tend to engage in this behaviour in front of other people. So that is a real challenge. However, it's also very common in these types of claims for there to be no witnesses to the conduct and no documentary evidence. And so that's when a person's oral evidence of the conduct will be important. And if there really is only oral evidence of the perpetrator and the person who experienced the sexual harassment, then a court or tribunal can make a decision on the basis of that oral evidence, comparing sort of the credibility of the complainant's evidence as against the perpetrator's evidence. Of course, it can be if somebody is experiencing sexual harassment or discrimination, if it can be very, very helpful for someone to take some notes or to take a diary of what's happening to them. Of course, that's not always possible, and often people don't have that sort of evidence, but of course that would be helpful. But it's very common in these cases for people not to have that documentary evidence and not to have the witnesses. And whilst that makes the claim more difficult, it does not it is not a bar to a person achieving an outcome in a sexual harassment claim necessarily.
Thank you.
No, that's fine. So moving on to racial and religious vilification. So although linked to discrimination, racial and religious vilification is its own standalone protection. This image on the slide is one that people may or may not be familiar with. It's of Adam Goodes, who's an Aboriginal man and who is also a very successful AFL footballer. In this image, he's being subjected to racial slurs and taunts from the crowd at an AFL game. Because Adam was subjected to very serious racial slurs and it took place in a public venue, this is the type of conduct that could be protected by racial and religious vilification. So people are protected from racial and religious vilification under both our Victorian law. We've got the Racial and Religious Tolerance Act, and also our federal laws, so which is the Race Discrimination Act. You may remember that when I spoke about discrimination protections, those are limited to to conduct that occurs in specific protected areas of life, whereas the protection for racial or religious vilification also applies to conduct that occurs outside of those areas. So it could be something that occurs in public and not necessarily in one of those protected relationships. However, these laws only apply to public conduct, so they're not going to protect any private interactions, such as things that happen within a person's home. Some examples of the type of conduct that these laws can protect against, as you can see on the slide, things like racially abusive comments at sporting events by spectators, by other players, by coaches or officials. Also being subjected to racially abusive comments in the street, in a park or on public transport. And that's important because, as we talked about earlier, generally things can't be discrimination where they've occurred on the street or in a park or on public transport, because they're not within those protected areas of life. This is also going to extend to things like racially offensive speeches at a public rally, racially offensive material on the internet, on blogs, social networking sites, and racially offensive comments or images in a newspaper or magazine. So there's an element of them being public information. Racial and religious vilification is a particularly complex area of law, and we certainly recommend that people seek legal advice before filing a vilification claim, particularly because the protection under the Victorian Act and the Federal Act are different. The definitions are quite different, and so it will be important for a person to get advice on which of those pieces of legislation is the best one to file a claim under.
No, thank you so much, Jen, because I think it has been particularly for our international students and some of our graduates from particular different countries that the COVID-19 has kind of led them to be in, very unfortunate situations where often very unwanted, disrespectful comments have been made in public, in trams and other, public places. And I think feeling that feeling of the sense of pain and loss when you find yourself in a new country and then subjected to this kind of behavior is something, where people having that comfort of being able to talk to someone to kind of know what your rights are, even though you happen to be from a different country. I think it's very important for us to disseminate this information.
Absolutely. And we really encourage, and particularly in the current climate, knowing some of the really unfortunate impacts of COVID-19, we really encourage people to call us if they've experienced any of these kinds of incidents over the last few months. And, it is, as I said, a particularly complex area of law. And unfortunately, the bar, for example, under the Victorian Act is set quite high for the protection, but we still encourage people to speak with us and get some legal advice. And there may be other options that we can suggest at that time as well, because it's not acceptable that people would ever be subjected to that kind of conduct. One thing to note in relation to that is, so the Victorian law protects racial and religious vilification. The federal law only protects racial vilification, and at the moment we actually don't have vilification protections for other attributes like gender identity or sex or sexual orientation. So it is at this stage limited to race and religion. We did cover it briefly earlier, but there is unfortunately a fair bit of conduct that falls outside of discrimination protections. So for example, as you can see from the slide, bullying in the workplace or in another setting is not something that will be protected under discrimination law unless the bullying is linked to or because of a protected attribute that the person has. But general bullying is not going to be protected under discrimination laws. But there are, particularly in a workplace setting, there are mechanisms to bring, to make applications about bullying under the Fair Work Act. And the other thing that doesn't always fit squarely or well within discrimination protections is some forms of everyday racism that people can be subjected to. So this could be, acts that are they're clearly racist, but that don't meet the threshold for the racial vilification laws, or they don't occur within an area of life that's protected by discrimination laws. So, for example, things like someone refusing to sit next to another person on public transport on the basis of their race or religion, which is clearly racist conduct, but is not necessarily going to fit into either of those protections. And similarly, the idea of someone crossing the street to the other side of the street because they have prejudicial or stereotypical assumptions that they've made about a person because of their race. Again, it's happening with a stranger, so not in a protected area of life, and it's not going to necessarily meet that high bar to be protected by racial vilification. Having said that, I still would recommend people, where they're unsure about whether the conduct falls into one of those protections, to call legal aid and get some advice on it. It's better to get the advice and find out whether you have the protection, than sort of have to keep wondering or not get to take any action in relation to it. So I will provide some information at the end of the presentation about how to contact our team.
Thank you.
In terms of the options for making a discrimination complaint, I think, as I touched on earlier, when someone's deciding what avenue to take to make their discrimination complaint, they've got a few options, because we've got both the Victorian specific laws and the federal laws, and people can generally decide which law to bring their claim under depending on which one is more favourable to that particular case. And also there's different time limits under both as well. So because there's these different options, we really do encourage people to seek advice actually before they bring their claims, so that they can get advice on which would be the best forum for them to make their claim in. And depending on which piece of legislation you decide to make your claim under, you would be making it to different bodies. So we've got the Victorian Human Rights Commission in Victoria, and the Australian Human Rights Commission federally, and then also VCAT, the tribunal in Victoria, and the federal courts as well federally. So there are different options. And it's also worth noting that there are some options under the Fair Work Act for including a complaint of discrimination there as well. So given all of those different options, it is a really good idea to get advice at a very early stage before making your complaint. And I just wanted to give a brief overview of the ordinary process for making a discrimination claim. I think this is important because most claims will resolve. So that is, someone will get an outcome without that person needing to step foot in a court or a tribunal. So most people will get an outcome without actually having to go to court or to have a final hearing of their claim. And I think that's important because otherwise the process can seem quite intimidating. If you feel as though as soon as you make a claim, you're going to have to give evidence and be in a courtroom, that's really just not the way the process works. So ordinarily a person would start by getting legal advice or legal information from legal aid. There's also some other community legal centres who can advise on these claims, or one of the human rights commissions as well. And from there, there could be an informal negotiation that can happen with the employer or the university or whoever it is, or we could, in some instances, write a letter to start with, requesting that particular adjustments are made or particular conduct stops, or it may be that the first step is to file an application in one of the commissions, so in the Victorian Human Rights Commission or the Australian Human Rights Commission if it's under federal law. And these organisations, the commissions, they're not courts, and they don't make a final decision about the claim. They just assist the person to get a solution or outcome to the complaint. So this is often by organising a meeting with the discriminator, often called a conciliation or a mediation. And the idea there is for the parties to come together and try and reach a resolution of the dispute without the matter needing to progress to a final hearing. If matters don't settle at that stage, then they can progress in Victoria to VCAT, which is the Victorian Civil and Administrative Tribunal, or federally, they can go to the Federal Circuit Court or the Federal Court. But even then, once they're lodged in a court or tribunal, it's not a case that they're going to go straight to a final hearing. They're still going to have another opportunity through a mediation process to try and resolve the complaint with the discriminator. And at that stage where you're negotiating an outcome, applicants can seek quite creative outcomes because it comes down to what the parties are willing to agree on to settle the matter. And I will talk more about that later on in the presentation, some of the outcomes that people can seek and get as part of their discrimination claim.
I'm just aware, Jen, we have about 5 or 10 minutes left. And, if there are any questions people have, can you please ensure that you type them off and send it to me? Because I think it is a complex area. And so if people had, we definitely would be encouraging you to ask any questions. But other than that, Jen, I think we've got about 10 minutes to kind of complete the session.
All right, not a problem. I might just touch briefly then on a case study, and then there's not too many more slides, so we should be able to...
No, it's okay. I think it's important information. So even if you kept going, we definitely think it's important.
Okay, all right, great. Thank you. So the slide here is an example of a case study of a potential discrimination issue. So I'll just read it out, and then I appreciate it's not a discussion situation, so I might read some questions and then sort of give people a chance to think about them and then give the answers. So Min is 34 years old and she has 2 children at primary school. She's seeking a job as a receptionist and was selected for an interview. During the interview, one of the interviewers refers to the personal details on Min's job application and says, "So you were born in China?" Min responds that she was born in China, but she is Australian. One of the interviewers asks Min how she thinks that she would fit into a team that are all very Australian and are all male. Min is really shocked and hurt by this question because she has lived in Australia most of her life and she is Australian. Min receives a call from HR the following week advising that she was not successful in obtaining the job as a receptionist. Min is concerned that she was not selected for the job because of her Chinese background and because of her sex. So some considerations from what we've talked about, which protected attributes would be relevant here. So in this case, the attributes of race and sex would be relevant to Min's claim if she was to bring a discrimination claim about this job interview. Which protected areas of life did this take place in? So this has taken place in the area of employment, but specifically job applicants have an explicit protection in our discrimination law from discrimination that occurs within a job application process. What is the discrimination, or what is the unfavourable treatment? So the interviewer has asked Min a discriminatory question during the interview. So that in and of itself would give rise to a claim of discrimination, but also Min could argue that she was not successful in obtaining the job as a receptionist because of her race and or her sex. What might be some of the difficulties for Min in proving that the reason that she was not successful in obtaining the job as a receptionist was because of her race and or her sex? One of the difficulties will be that when, well, we don't have too much information, but when HR was speaking with Min, they didn't provide any explicitly discriminatory reasons as to why she was not successful in obtaining the role. And in fact, they may not have provided any reasons at all. Therefore, an inference would need to be drawn that Min's race and or her sex were the substantial reasons that she did not get the job. The other difficulty is that Min doesn't have any information as to who the successful candidate was. And that's one of the real challenges with job applicant discrimination cases, is that generally that knowledge about who the successful applicant was is exclusively within the mind of the employer or the organisation or HR, and the applicant themselves doesn't have that information. So you know, if the successful candidate was chosen because they had more experience in this type of role than Min, it will be difficult for Min to prove that the substantial reason that she did not get the role was because of her race or sex. So it can make these types of claims for job applicants quite difficult in terms of proving discrimination.
That's a very interesting case study, and I think many people can relate to that in different aspects of their, you know, career development.
It's really challenging because you can personally know what the reason was that you didn't get the job, but proving it can be another matter, and that can be very, very frustrating for people, where they feel that they know what the reason was, but having the proof when that knowledge is exclusively in the mind of the person, you know, the recruitment personnel, can be really, really difficult.
So Jen, you know, it's been very valuable information. So, I mean, I guess the graduates have got a very good overview, but we always encourage people not to kind of shy away from seeking legal advice, you know, like, and where would people kind of seek this information?
Absolutely. I think because we're coming to the end of the hour, I'll move through to the information about our program. So you can contact the Equality Law Program at Victoria Legal Aid via our legal help phone service. So you can see there's a 1300 number there, on the slide. And what will happen is you'd have an initial triage conversation with legal help, our legal help team. And if your referral relates to discrimination and sexual harassment, then it will come through to our team, and a lawyer from our team will contact you to give you some legal advice over the phone. So that would be the best way to contact our service. And, you know, if in talking to us, we find that the issues is more of an employment law issue and another type of issue, we'll then provide you with some appropriate referrals to assist you with that as well.
So just a couple of questions, Jen. Just, you know, I think for all our students or graduates at the university, is this a free service, or, you know, do people have to pay money for it?
Yeah,
and, you know, these are very important things for graduates to know.
Of course. So the legal advice by phone, so any advice that we give by phone is free. And some assistance that we provide is also free. So we can provide some assistance, some limited assistance, such as writing a letter or undertaking some informal work we can provide for free. And then there are some small fixed costs associated with some work that we do on a file, but they're small fees compared to, for example, a private firm. But we certainly, all of the legal advice is free.
Absolutely. And can I just say, can I just also confirm, I'm sure everybody knows it, but since it's an equality law practice, that you don't really need to be an Australian citizen or hold a particular green card, Medicare card to kind of access the service?
Definitely not. Absolutely anyone can access the service. There's no restrictions on that. The only restriction I will say that there is that we advise people who've experienced or been subjected to discrimination or sexual harassment. We don't provide advice to people who've been accused of or who have perpetrated discrimination or sexual harassment. That's the only restriction on our service.
Thank you. So, Jen, thank you so much. It has been such a comprehensive and well-articulated presentation. I think, you know, really suits the needs of our graduate community. And I thank you for the presentation and the time that you've put in to the information, very relevant to our, for our graduates. And at GSA, I think the most important thing for us to kind of communicate to you all who are listening to this program, or, you know, who may share this information, is just to ensure that, you know, your rights, you have the right to protect yourself. And even if you're a student, even if you are your program is managed by your supervisor, or people ask you information, is don't feel that you know, you don't want to seek information and get clarity about your rights. And it's very, very important. GSA also has a 1-800 number, which we have promote on our website. We will definitely ensure that we can give you referrals to either AMSU, the University of Melbourne Legal Service, which is also an independent organization, but definitely to the Equality Law Program on 1300-792-387. So thank you so much, Jen, for your wonderful presentation. And a big thank you to all the participants who've raised some fantastic questions too. So it's always good to have an interactive audience. So thank you so much.
Yes, thank you, Rachna, and thank you everyone for your questions. Really appreciate it.